Jefferson County Court at Law number 2 is back in session. The court is in session in 2 cases. Cause numbers 26 CCCR 1056 and cause number 26 CCCR 1064. Cause number 26 CCCR 1064 and cause number 26 CCCR 1155. Both cases are styled the state of Texas versus Devin Wayne Jones. Mr. Jones, is that your full name?
Yes, sir.
Mr. Jones, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Jones, you may put your hand down. How are you doing, Mr. Jones? I'm doing fine, thanks for asking. Mr. Jones, I have before me, before we get started, you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
Yes.
Okay, now, Mr. Jones, I also have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Right.
And are these your initials on the line that state you like to waive your right to have an attorney and will represent yourself?
Okay.
You also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. Do you recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Jones, you have the wrong number on here. Put 55. That's he's pleading to
That one wasn't on the line.
Oh, it wasn't on there.
okay. Mr. Jones, in cause number 26 CCCR 1155, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Devin Wayne Jones, owner by January 12th, 2026, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of burglary of vehicles. Mr. Jones, do you understand what you've been charged with?
Yes, sir.
To this charge, how do you plead? Guilty, not guilty, no contest.
No contest.
Now, you're pleading no contest freely and voluntarily,
Yes, sir.
and are you pleading no contest because you do not wish to fight or contest the charges?
The exact reason.
That's okay. Now, Mr. Jones, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? Oh, let me do this. This is the next one. Do you recognize this document?
Yes, sir.
Okay. On page 2 of this pen is come on. This thing is acting up.
Was another? Or no?
Yeah, let me try it. The other pen. Okay. Oh, he needs a tablet. Okay, Mr. Jones,
Yes, sir.
on page 2 of the same document, there are 2 sets of initials. First set of initials on the line next to a box is checking the contingent, which means no contest. Would you place your initials here?
Yes, sir.
Second set of initials are on the line next to a statement that reads, I do not request to discover. I waive my right to discover in this case and choose to enter a plea of guilty or no contest. Did you place your initials in the second location? On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Correct.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Jones, before you signed and initialed all of the documents that I showed you, Did you read the documents?
Correct.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
To the best of my knowledge.
Mr. Jones, are you a citizen of the United States?
Yes.
State offer states one, Your Honor.
Mr. Jones, the state is offering State's Exhibit Number 1 to be used as evidence in your case. State's Exhibit Number 1 is this first document that I showed you on this tablet. This is the same document that has your initials in these two locations, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Correct.
Okay? Mr. Jones, is there any evidence that you are currently mentally incompetent to stand trial?
No.
Okay, Mr. Jones, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what's the agreement in this case?
It'd be confinement in the county jail for a period of 90 days, probated for 1 year with 24 hours of community service, $1,200 in restitution payable to the complaining witness in this case, Alexis Bairden. And in exchange for Mr. Jones's plea in this case, the state will be dismissing cause number 26 CCCR 1064.
No fine, right?
No fine, Your Honor.
What's the court cost? Okay, now, Mr. Jones,
Yes, sir.
the state is offering that you serve 90 days in Jefferson County Jail, but you would not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you will not be required to pay a fine. You will be required to pay court costs in the amount of $292. You're required to pay a probation fee of $60 a month, your analysis fee $15 a month, and a reimbursement fee of $15. And you're required to pay restitution in the amount of $1,200 to, is that Alex Bearden?
Alexis Beard.
Alexis Bearden? And Mr. Jones,
Yes.
your total monthly installments in this case, well, you also required to pay a reimbursement fee of $15, restitution in the amount of $1,200 to Alexis Bearden. And your total monthly amount that you're required to pay each month is $219 a month. Are you able to pay the
Oh.
200?
How long?
A year.
Well, actually, it's 11 months, but it's
Hmm.
while you're on probation.
So what I owe, 2, 4, 6, 8, 10, 12, 14, so I owe like $2,600?
It's more like, if over the year, it'll be 2,407. Okay,
Mm.
half of that is the restitution.
Okay. So
Okay,
but I could pay the whole 20.
if you want to do that,
That's cool.
so will you be able to pay the $219 a month?
Yeah, I'm gonna pay it, I guess, unless you wanna make it cheap.
No, no. I'm saying,
He's
but you
negotiating.
saying you can pay it, right?
Yeah, it's cool, but I have a question. If, let's say I was held in Jefferson County from another county, from a whole, right? You see what I'm saying? Like, I was in Jefferson County, but I have
Not on this case,
right.
because this case is, no,
Right.
not on this case, because you never been oh, yeah,
That's why I want that. I was
All
curious
right.
about
okay. So, you're able to pay the $219 a month, is that correct?
that. That's cool.
And, let's see, there's 24 hours of community service, right?
Yes, Your Honor.
And you will also be required to adhere to the other standard terms and condition of this probation. The state will be dismissing the companion case. And the companion case is cause number 26 CCCR 105.
No.
Excuse me, no. 26 CCCR 1064. Okay,
Another question. If how would it work? Like, if I pay the 2,400 total and I do.
well, you got a whole, you still got your community service to do?
Yeah, I'm gonna do everything.
Okay, well, then your probation officer can tell you what you need to do. Okay, now, do you understand the state's offer?
Yes, sir.
And do you accept the state's offer?
do.
Okay, I'll follow the plea bargain agreement that you have entered into with the state. This is P. Let's see, this was plea. Let's see, dismissed. Okay, this is,
So the jail thing,
hold on, she'll tell you, what to do. Okay, so you're gonna stand in front of the,
the chair,
yeah, stand in front of her. Jefferson County Court at Law number 2, here you go. Get it. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 25 CCCR 2148. Case of style, the state of Texas versus Christy Wiley. Ms. Wiley, is that your full name?
Yes.
Ms. Wiley, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Wiley, you may put your hand down. How are you doing, Ms. Wiley? I'm doing fine, thanks for asking. Ms. Wiley, you're represented in your case by your attorney, Attorney Tom Burbank. Ms. Burbank, how are you doing? And Mr. Burbank, do you waive a record in Ms. Wiley's case? Ms. Wiley, I have before me a document. Well, first of all, Ms. Wiley, the state is represented in this case by Attorney Fair Nixon. And Ms. Nixon, how are you doing?
I'm fine, how are you?
I'm doing fine, thanks for asking. Now, let's see, Ms. Wiley, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office, and in this information, it alleges that you, Christy Wiley, on or about August 3rd of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest, search, or transportation. Ms. Wiley, do you understand what you've been charged with?
Yeah.
And to this charge, Ms. Wiley, how do you plead? Guilty, not guilty, or no contest? Are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Now, Ms. Wiley, prior to us starting this plea, you signed a document that is titled misdemeanor plea admonishment. It's also labeled as State's Exhibit Number 1, and you place your initials on page 2, and the initials were on a line next to a box checked no contendere. Is that correct?
Yes.
Which means no contest. And then you sign that document on page 3 above the line that is titled defendants, that is titled defendant. Is that correct?
Yes.
Now, did you also sign a document that is titled trial court certification of defendant's right of appeal? And at the top of that document, there are 2 statements that was checked. The first statement stated that that was a plea bargaining case and you have no right of appeal. Do you understand that?
Yes.
And then the second statement states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes.
And you also have a document that you signed on paper that's titled discovery certification. Is that correct?
Yes.
Now, before you signed and initialed all of the documents that I've just mentioned, did your attorney go over the documents with you? And did you understand everything that your attorney went over?
Yes.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Ms. Wiley, are you a citizen of the United States?
Yes, sir.
State's Office of State Exhibit 1.
Any objections? No objections. State's Exhibit Number 1 will be admitted. And Mr. Burbank, you advised and counseled Ms. Wiley. Is there any evidence that she is currently mentally incompetent to stand trial?
No.
And Ms. Wiley, your attorney, Mr. Burbank, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes.
Ms. Wiley, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, Your
And what
Honor.
is that agreement?
Essential terms as follows: 6 months deferred probation, a $250 fine, and 25 community service hours.
Okay, Ms. Wiley, the state is offering that you serve 6 months deferred adjudicated probation. During the 6-month probationary period, you'll be required to pay a fine of $250 plus court costs of $327. You'll also be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15, and you'll be required to reimburse Jefferson County Court appointed attorney's fees, in this case of $350. Now, your total monthly installments, that is a total amount that you will be required to pay each month, is $278 a month. Are you able to pay the $278 a month? Okay, now, Ms. Wiley, I need her affidavit. Okay. That's 20. No, 277. I need to change that there. Okay. Ms. Wiley, I'm handing the attorney a document that is titled Affidavit of Indigence. Do you recognize that document?
Yes.
Is everything in that document still true and correct today?
Yes.
Okay, now, Ms. Wiley, the court is going to find that you're still indigent, and based on the finding of indigency, the fine of $250 plus court costs of $227, which comes to a total of $477. Which comes to a total of $527, will be converted to 42 hours of community service. The attorney's fees of $350 will be waived pursuant to Article 26.05 G-1 of the Texas Code of Criminal Procedure. The reimbursement fee of $15 will be waived pursuant to Texas Code of Criminal Procedure, Article 102.018. And the probation fee in this case will be reduced to the statutory minimum of $25 a month. And you'll be required to pay the $15 probation fee each, not the probation, $15 your analysis fee each month. So your total monthly installments that you will be required to pay each month is $40 a month, okay? Now, you will also be required to perform 25 hours of community service in addition to the 42 hours of community service that was converted from fine and court costs, which comes to a total of 67 hours of community service total. And you'll be required to adhere to the other standard terms and conditions of this probation. Ms. Wiley, do you understand the state's offer?
Yes.
Do you accept the state's offer?
Yes.
Ms. Wiley, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Wiley, you'll stand, just have a seat in that chair, wait for your name to be called. Once your name is called, you'll follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go and you have a blessed day. And Ms. Wiley's next case is gonna be reset. Is
Yes,
that's what y'all doing? Okay. and we reset and we're gonna keep it on the trial docket?
We could, but yeah, just on the safe side, Judge, I think it's gonna get worked out.
Okay, reset. So that's gonna be reset for trial. Okay. Now, Mr. Burbank, you free to go? You have a blessed day, I think. Oh, he does? Oh, the guys, oh. That's Ruben.
Yes, sir.
Okay, Mr. Ruben, your case, I think you were the number 3 case. So we have 2 cases ahead of you. So Mr. Rife Kimler case is gonna be going to trial. So your case is gonna be reset. We're gonna reset him for trial. Okay. This is Joseph Rubin. Get my trial date. And he has 2 cases.
Oh, yeah.
He's on Zoom.
Right there.
He's on Zoom up there.
August 3rd.
Okay, August 3rd, Mr. Burbank,
Yes, Your Honor.
these cases are gonna be reset to August 3rd.
Yes, Your Honor.
And both cases. Okay, Mr. Rubin, your case is gonna be reset for August 3rd, 2026. Your attorney and your bondsman will get notice of reset. Stay in contact with your attorney and your bondsman. You're free to go and you have a blessed day. And Miss Christy Wiley, calls number 25 CCCR 2149. That case will be reset to August 3rd at 9 AM as well.
Would you like this? to-
Yes, and Mr. Rubin, you need to be here in person.
Yes, sir.
All right. All
All
right.
right.
All right. You free to go and you have a blessed day.
Yes, sir. You too.
All right.
Okay.
Yes, you may be excused. You have a blessed day.
Thank you.
You can sit in the jury boxes.
See, you asked me how.
And
Ask me.
instruction,
That's just some ears he got.
Yes,
electronic, you report electronically over here, you find some something to do, but you're physically.
you just pay one time. You don't have to pay the boat.
Yeah.
And what?
We'll tell you that at the end of the plea.
Voting. Number two.
Mr. Garcia, you're gonna step into that first row of chairs behind the wall and just go all the way to the first chair all the way on the end. Bowden, you're gonna sit next to Mr. Garcia. Ms. Coy,
Yes, sir.
there's gonna be a seat between you and Mr. Bowden.
Yes.
Ms. Brewer, you'll sit next to Ms. Coy.
Number six. King.
Sit next to her.
Blunt.
King, is that Howard?
Yes.
You'll sit next to Ms. Brewer.
King.
Mr. King, you'll sit next to Mr. Howard. And Mr. Blunt, you're gonna go in that first row of chairs, and you're gonna sit at that first chair on the end, down there. Keep walking. Yes, and Miss, is that Sundgren? You'll sit next to Mr. Blunt. Mr. Calendar, you sit next to Miss Sundgren.
Yeah.
Miss Haley, you'll sit next to Mr. Calendar. Miss Kepley, you'll sit next to Miss Haley.
O'Neill.
Miss Gatling, you'll sit next to Miss Kepley. And Miss Odell, you're gonna that second row of chairs, you're gonna walk all the way down to the first chair on the end, and that's keep walking all the way down.
Dennis.
And Miss Della Rosa, you'll sit next to Miss Odell. And Miss Thomas, you'll follow Miss Della Rosa and sit next to her. Mr. Dennis, you'll sit next to Miss Thomas. And Mr. Owens, you'll sit next to Mr. Dennis. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are handled in the district court, whereas your misdemeanor cases are handled in the county court or county court at law. The case that we have before us today is a criminal case. You have been called for jury duty on this criminal case. You will be examined for inclusion on a jury hearing this criminal case. Now, courtroom hours normally vary. They're normally 9 a.m. to 5 p.m. However, in this court, we have a lot of large dockets. And what a docket is just a list of cases. For example, on yesterday, we had a trial docket, pretrial conference docket, and an announcement docket. Today, we had what is called an arraignment docket. An arraignment is where individuals come to court for the first time after they have been charged with an offense and they have been booked in, and have been released from jail, and they're out on bond. So we had that this morning. And also we had some other things, other activities that were taking place in court while you were out in the hallway. Now, as I mentioned to you earlier, our courtroom hours are normally from 9 to 5. However, because we have large dockets in the morning, we have our juries at 1:30. Now, whether you're selected as a juror or not, you're performing a significant service which only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which requires a careful and correct trial. If selected on the jury, unless otherwise instructed, you will be permitted to separate yourselves for recess, for meals, and at night. At this time, I must administer to you the first of two oaths. So therefore, I need each and every one of you to raise your right hand. And once I finish administering the first oath, please say, I do. Do you and each of you do solemnly swear or affirm that you will make true answers to questions that may be asked of you by the court or under its directions touching your service, qualifications as a juror, so help you God? Please say I do. Okay, you may put your hands down. The law requires that each of you must possess certain qualifications before you may be considered as a juror in this case. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you have been seated on a jury, a mistrial can be declared, the case could be retried, and you may be held in contempt of court. If you're held in contempt of court, you could be placed in jail for up to 180 days and be given a fine that does not exceed $500. Now, the way I'm going to ask the questions, I will ask a series of questions. I do not want you to answer those questions out loud. Just please answer the question to yourself. And then once I finish asking the last question, and the last question is after I ask the last question, I will then ask, is anyone disqualified under the law? And if you think that you may be disqualified under the law, then I will ask that you will come up and you're going to stand up to the left side of the bench. This is the bench. And the reason why it's the left side because we have our court reporter sitting to the left, and he will have a microphone right here on the bench. And so the other thing is we are currently airing on YouTube. I will turn the YouTube off. And then I will turn the microphone off as well. And then I have a noise sound device that sounds like this. And the reason why we will do that is because we do not want the other jurors to hear the discussion. Okay? So again, I will ask a series of questions. Please do not answer those questions out loud. Just answer those questions to yourself. And then when I finish asking the last question, I will ask, is anyone disqualified under the law? If you think that you may be disqualified under the law, just simply raise your hand and then we'll have you come up to the bench. First question. Except for failure to register, are you a qualified voter in Jefferson County and in the state of Texas under the laws and constitution of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause before I ask this question is because I need to inform you that I'm required to ask this question by law. I'm not trying to pry into your personal affairs. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? And this is the last question. Have you served as a petit juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Is anyone disqualified under the law? If you think you may be disqualified, please raise your right hand. Okay, we have one person raise their right hand, and that is Geraldo Garcia Martinez. Mr. Garcia Martinez, you can come forward. Okay, now I would determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them if one of these exemptions apply to you, but you still desire to be considered as a juror. Please continue to remain seated. Now, I will ask these questions in the same manner that I asked the previous questions. That is, I will ask a series of questions. Do not answer the questions out aloud, just answer the question to yourself. And then at the end, I will ask if anyone would like to claim an exemption. And if you would like to claim an exemption based on the exemptions that I'm getting ready to state, just raise your right hand and we'll ask that you will come up. Okay. First question. Are you over 75 years of age. Do you have legal custody of a child or children under the age of 12 years, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled in an actual attendance at an institution of higher education? Are you an officer, employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in Jefferson County during the past 3 years preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States military forces serving on active duty and deployed to a location away from your home station and out of your county of residence? Is there anyone on the panel who'd like to claim an an exemption? Yes, okay. Yes. 16. Ms. De La Rosa, would you please come forward? Okay. Okay, ladies and gentlemen, I will now move to excuses. With the excuses, I will not be asking any questions. I will make 3 statements. And once I finish making the last statement, if you would like to claim an excuse based on the 3 statements, then I will ask if there's anyone who'd like to claim an excuse. You'll raise your hand and then you'll come before the bench. First statement: a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the defense and without the consent of the state. And the last statement, a juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Okay? Is there anyone on the panel who'd like to exercise an excuse? Okay. We have two people. We have juror number 17. Please come forward. Let the record reflect that the court is back in session. And at this time, all the members who are remaining on the panel are qualified. They're not claiming any exemptions or any excuses. So at this time, state, are you ready to proceed?
Yes, Your Honor, we are.
Defense, are you ready to proceed?
Yes, Your Honor.
Okay. Okay, ladies and gentlemen of the jury, the court is convened in cause number 23 CCCR 0744, case is style of State of Texas versus Kiana Bailey. Let the record reflect that Ms. Bailey is present in court with her attorney, Attorney Wright Kimler, state is present, with Assistant Criminal District Attorney, Attorney Fred Vernon, and Assistant District Attorney, Attorney Farrah Nixon. Okay. Again, members of the jury, you have been summoned to this court as a prospective witness, excuse me, as a prospective juror in this criminal case. The defendant, as I mentioned to you earlier, is Miss Kiana LaShawn Bailey, and she's represented by her attorney, Attorney Wright Kimler. And again, the state is represented by Attorney Farrah Nixon and Attorney Fred Vernon. Our court reporter is Mr. Sebastian Aguilar. He's sitting to my left. He will be taking down everything that's being said, so speak up when you are answering or asking questions. The bailiff in this case is Miss Brenda Mosby. You met Miss Mosby. The defendants in this case, Miss Bailey stands charged by information with the Class A misdemeanor offense of assault causing bodily injury. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not trying to meddle into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we can discuss the matter more privately. State, are you ready to proceed?
Yes, Your Honor, we are.
And defense, are you ready to proceed?
We're ready, Your Honor.
Okay. And Mr. Vernon, the panel is yours, and both parties agreed to 25 minutes. Is that correct?
Yes, Your Honor. Yes, Your Honor.
All right, I'll be keeping the time. Mr. Vernon, you may proceed.
Your Honor. May it please His Honor,
Yes.
how's everybody doing? Well, as the court has stated, my name is Fred Vernon, and I represent the state, I represent the community, and on behalf of the state and community, I welcome you CC2, as we call it. Before we jump in, I'm going to give an overview, kind of an agenda of how we're going to proceed for my presentation here to you all. And so first, we'll begin, I'll answer some questions for you all that you may have had since yesterday. I'll answer some of those questions for you. We'll go over Voyard, exactly what it is and what it is not. Then I will share with you all some things about myself. In exchange, I'll ask them to share some things about yourselves with me. And then we'll move forward, and I will go through the law. I will explain what evidence is, what it is not. I will also discuss the elements of assault, and then I will discuss burdens of proof and what that actually means. Then we'll go through phase of the trial, and if you are selected, what you can expect going forward. And if we have time, I'll ask everyone, one big question. And so I'm looking forward to getting to know you all. Very short. First, some questions that you all, I'd like to answer to you all that you may have had. Why do I have to wait so long? If I presume correctly, you all were here yesterday? Okay, yesterday? Why do you have to wait so long? First, I acknowledge it's a big inconvenience. But the truth of the matter is, this court has a large docket, and everyone has a right to a fair and just a process, due process, as we call it. So sometimes that takes time. Martin Luther King said, sometimes the moral arc of the universe is long, and sometimes it moves slow, but it always bends towards the will of justice. Thank you for your patience. The next question you may have had is, what are you gonna be expecting in the coming days? Well, you're gonna hear from myself, you're gonna hear from the defense. You're ultimately gonna be, some of you will be selected to sit, as a juror, some of you will be alternate. Okay, and then, once that happens, we'll proceed with the trial of your evidence and witness. So what is board document? Has anyone settled in jury trial before? Yes, sir?
Yeah.
Okay, and, how was your experience?
I had a long, 5 days, and then they said, well, like, fourth and fifth day, once they got to the, we're about to give our verdict.
Is that a civil case or a criminal? Civil. Anyone else? Yes, sir?
It's good experience. In fact, that's the time we got 5 days.
Was it, civil, board out criminal? Did you make the cut? Were you part of the jury panel?
Yes.
And what was the verdict from that?
Still for that time.
What was the nature of it? What was the offense? Do you recall?
One guy escaped prison. So, and then the next one was,
Anyone else? Yes, sir?
federal court.
Federal court? Is it a criminal or civil matter?
Criminal.
And, you made the, jury panel? And, the verdict was?
Guilty possession, guilty possession of weapon.
Okay. All right, well, voir is an old French word. It means to speak the truth. So today, I'm gonna speak the truth to you. And when I ask you some questions, I hope that in exchange you'll speak the truth to me. And that way we'll get to know each other and have open, honest conversation. Also, I wanna make sure that you all understand that the tone here is very informal. So if you have a question, just raise your hand. You're welcome to call me by my first name. My name is Frank. So, is it okay with you all if I call you by your first name? Okay, very good. So as we proceed, some people call it jury selection, board jury selection, some call it jury deselection, okay? So how does one move from this side of the well to that side of the well? Sure. Well, what happens is the defense or myself, we have something called strikes, or like I like to call it a release, okay? So we release a person who can't be fair, impartial, just, focused, or they just don't want to be here for others to be here. Would allow us to excuse them. So me personally, why do I release someone? Or use my 3 releases to release someone? It's because I find after having an open, honest conversation that someone isn't fit to execute their duties as a jury team member, as I call it, a jury team, because it's a cohesive unit. Second reason is a person says, hey, I can't set aside my bias, or I have a prejudice against something. It doesn't mean a racism, but that just means I dislike something and I'm not willing to set that aside so I can be fair and impartial. Bias me, I like that thing so much, I'm gonna make an unfair decision for the other side. Okay, so today I'm gonna seek to drop or affirm that you do not have prejudice or bias, and if you have it, are you willing to set it aside to be fair and do justice? So you can think of yourself as a legally empowered team of jury or ambassadors for the community to come here and do justice. Well, whether you're faced with being a part of this jury or not, this moment right here is very important. And you're already a part of that team working to effectuate justice for the community. So why do we have 6 or 12 people in the jury? Why is it not, why don't we just have a judge that makes the decision whether someone's innocent or guilty? Why don't we let the president of the United States, the government? Does anyone answer that question? Does anyone know why? Anyone want to volunteer for why? I will tell you, it's because the founders of this country lived under a king, and they found that system where a king decides who's wrong, who's right, what the facts are, they decided that doesn't work. That's not good for one man to have all of that power. So what they did is they entrusted that responsibility to a team of jurors, as I call them, to come together, and then and only then can a person be found guilty. So that's why I call it a team of jurors, because a person cannot be convicted, cannot be found guilty unless a team of members of the community come together, review the evidence, look at the facts and the elements, and decide if that person is guilty. Okay? So overall, a jury is an empowered team by the law that rely on the collective experiences, common sense, and their guts to determine justice. Let me ask, has anyone here played in sports or organized a team at one point in their life? Okay, I see a bunch of head nods. We're gonna start at this side of the room. Who has played on sport, a team dynamic? Okay, yes, sir? Softball. Softball? Okay, and what position did you play in softball? Center field. Center field? Now, I presume you won quite a few games when you played? Okay. Now, let me ask you, if you had some superstars on your team, is it possible for one person to accomplish and win that game and accomplish the goal alone?
No, of course not.
Why not?
Good, like you said, it's a team sport,
Team sport.
not an individual sport.
Yes, sir. Yes, sir.
You for baseball, football.
Okay, football? I like football. Let's talk about football. Where'd you play?
Played, at Newport News, receiver.
Okay, coordinations, receiver. Y'all do pretty good.
We weren't that good.
That's all right. But, the games that you did win, was it possible to do it alone?
Yeah. That team.
Anybody else care to share now?
Gymnastics.
Gymnastics, okay. The gymnastics team, they have meets, correct, where teams get together and they total up the points from individuals, okay? So is it possible if you were an outstanding gymnast, is it possible for you to keep a perfect score every time, to accumulate enough points to win the tournament? So justice is the same way, okay? Justice is the same way. We have to work together as a team of community members to accomplish justice. Okay, that's what we're here to do today. So you can think of it as the judge, the court, they're gonna call the balls and the strikes. Okay? Yourself, y'all the team members that are gonna be playing on the field. And that begs the question, what's my job? What's my role in all this, right? Well, my job is to help explain it for you. My job is to come here and I want to tell you the truth, to be honest. Number 3, my job is to come and provide you with sufficient evidence, give you the football, give you the practice beams, give you everything that you need so that you can go and find justice and feel good about it. This will not be a burden. Prosecutor does their job, it's not a burden to you. The burden is on me. So who am I? Brief history on myself. I'm the son of a father who's a Baptist pastor. A mother is a lifelong teacher, and they taught me a few things. 3 principles. Taught me to be humble, tell the truth, and taught me to work for them. So I promise you right now, a few days from now or a few hours from now, we go up and sit on that tree thing. And I promise you, that I will work my butt off to get you everything that you need to find justice and nothing short of that. Everything that you need to find the truth. I promise you, if a witness gets on that stand and they're shading the truth in any way, I will draw it out and I will expose it to you. You won't have to get it, so that you can find your way to the truth. So before we get to a brief one, I want to bounce some questions off of you guys and some more questions. Do any of you all have any personal relationships with anyone on this side of the way? Okay. We talked about who's been on the jury report. Thank y'all for telling me that, sharing that with me. More probing question. Where is the fist fight? Tell me about it if you don't mind.
I mean, I was a kid, I mean, we had this fight, so I haven't been in one in 50 years or
Mm-hmm.
yeah.
Okay. What about yourself?
Self-defense,
Self-defense. What happened?
defending myself,
Mm-hmm. Did someone approached you, or
yes,
you defended yourself and fought back?
yes.
How do you feel after that?
I generally don't like fighting.
Mm-hmm. Why not?
I don't like to get mad, and then I don't like the way I feel when I get mad.
Interesting.
So I don't like to, they're fighting loud, loud.
Thank you. Ma'am, and your name?
Dusty Kobe.
Ms. Gussie.
Yes, sir.
You've never been in a fist fight before, or anything like that?
No.
Have you ever seen a fight on TV?
Oh, yes.
How do you feel about that when you see those fights?
Well, just looking at it, I mean, I don't like it. But different reasons, you know, people might get involved in a fight, but I really don't like fighting. Physical fighting. I like this kind of fight.
Yes,
I'm a
ma'am.
teacher. I'm a retired teacher.
Ma'am. Well, Ms. Gussie, you said there's some reasons, to fight or not to fight. What are some of the, what's the reason you would say good reason to fight?
Possibly, to defend yourself. I don't think anyone just should stand there and just, punching back for anybody. But don't ever start anything. I taught my daughter that, my students that, and that's, but don't go around and try, just like I said, to start something just because you're so mad. There are other ways you can solve problems. Try to use before you get to that level.
What are some of those things you could use to prevent a fight before it happens, before it gets on that level?
Well, talking, try to talk to someone about, the problem. We've told students to, if you can, walk it out. Walking helps to relieve some of the stress, that you're mentally going through possibly, than to get to that level of physical, altercations and all this.
So what happens if someone walks away and then they're followed?
If you're followed, not a phone.
Yes, ma'am.
Call for some help, call,
Yes, ma'am.
someone you can depend on, is probably most likely a policeman or somebody that, is qualified to do that, or, so your family member or somebody else, contact someone, if you're followed, when I was younger, I could walking and running, but now, I kind of, but
All right. Yes, ma'am.
I'm still in pretty good shape, but
You look
but
great.
if they follow you, won't that, wouldn't like that at all.
Anybody else care to share or have a agree with her or disagree? See the wince on your face, what do you think?
It's like, fighting in general, I mean, I just like, just thinking like my family, like you're to, somewhere to try to harm them, I would do what I had to do to, protect them, but start fighting. It's well for both parties, really. I think there's maybe a certain time where it's, I'm not saying it's necessary, but, like self-defense or something like that, or protecting, somebody, maybe in that case, but never for, silly stuff.
Good, thank you. Anybody else? Yes, sir? Oh, Now, we talked a little bit about self-defense, very caught up, mentioned it several times. So, someone, same scenario, person walks away, just like we taught your students to do, and, someone followed. Someone then, that same someone who followed, takes their hand and puts it right on that person's forehead, knocks their head back. That person who got their head knocked back, they have a right to defend themselves. Yes. Yes.
Well, yes, I would be like, you did that to me, like, it might be a reflex, like that or something, but I'm not really a physical fighter.
Yes, ma'am.
But you touched me like that.
Yeah.
I'm gonna-
You're gonna have some reactions,
Yes,
right?
yes.
Sir? If someone bounces,
Oh, if somebody pushes you, then I'm probably gonna react.
okay? Now, someone bounces their hand over your head, snaps it back. How do you feel?
I would be ready to defend myself, and I don't think that would be like a reason to fight. Right, like it's a big warning, something about, something could go sideways, right, so you.
So we have heard, thank you. We have heard,
I guess it's not enough to form this like just do that, but still wouldn't defend yourself.
So,
Yeah. Yeah, that's, okay.
so, so we have heard from you, one part of it. Yeah, okay.
Yeah.
Now,
I'd probably just look at them, if they're waiting for your reaction.
Mm.
If you don't react,
okay,
not do anything, but.
okay. All right, well, now I'm gonna read elements of the law, and I wanna see if that changes your response. Assault is committed when someone knowingly causes bodily injury to another by striking, and the person who struck feels pain. So, is there anyone that thinks, blow or smash to the head, snapping the neck back does not or cannot cause pain, or can it cause pain? So, it cause pain, in your opinion, that's some.
I'm not able to visually see what's. You're describing what it is. What was the.
Okay, okay. Scarring, you see evidence of scarring or bruising.
I just think that like seeing, how much force was actually used, are we talking whiplash, is it enough that a person's knocked off of balance, like there's so many variables that are not given sort of just by your description.
Fair enough. What if you saw, direct testimony that the person themselves felt?
I don't really know how to answer that.
Fair enough, fair enough. Ma'am,
Being subjective.
and it's subjective, okay?
You can say it hurt and it didn't, but to prove a point.
Okay. Now,
Lots of variables that's going through my head. I'm at elementary school, we teach them, don't put your hands on each other, if one pushes you, don't push them back, you both get in trouble, but as an adult, you get hurt worse. Think about that time my daughter, when she was in the hospital at 9, have a plan, coming after you, be ready for stuff. You're getting hurt, I'm like, you gotta go get hurt.
You have 5 more minutes.
ma'am?
It would depend on what I was struck with,
Mhm.
and yes, I would defend myself. No, I'm not gonna sit there and just take it.
All right. Now, we're gonna, move quickly, we're gonna get to, what it means to convict someone. So we have a team of jury work together to find justice, but the state has a burden. I have a burden of proof, okay? And that burden of proof is beyond a reasonable doubt. The law does not define what beyond a reasonable doubt means, but I can show you what it looks like, and I can tell you what it feels like. Okay, so beyond a reasonable doubt is like this. You can imagine a staircase, okay? The stairs, and you proceed up those stairs. At the very base, we have what's called a reasonable suspicion, okay? Something might be going on, okay? Then you move a little higher, we have something called probable cause. That's what's needed to make an arrest, okay? Then you move a little higher up that staircase, and you have what we call preponderance of an evidence, like 50-50. Then you move a little higher, you have what we call clear and convincing evidence. We use that burden in family court when terminating parental rights. And we're at the highest level on the staircase, which is called beyond a reasonable doubt. Okay, so if you can imagine that staircase, that's what it looks like. I will promise you, I will climb up those stairs and get you to beyond a reasonable doubt, exclude the reasonable doubt from your mind. Okay, so that's what beyond reasonable doubt looks like. What does it feel like? Beyond reasonable doubt feels like every time you drive your car and you come to a four-way intersection and the light turns green. You feel comfortable enough to drive through that green light. You don't know for sure whether the crossing lanes have red lights. You just see the car stop. The lights are facing the cars, they're not facing you. You don't know what color the light is. That's called circumstantial evidence, okay? Because the cars are stopped, therefore their light must be red. My light is green, therefore their light must also be red, okay? And as you drive through that intersection, you know there's a chance there could be a drunk driver, there could be anything coming, that some kids ball could bounce out there could be something coming through that lane. But you're fairly comfortable with the fact that your light's green, and you presume that their lights are red, you're comfortable enough driving through the green light. That's what beyond a reasonable doubt feels like. Okay, so we know what it looks like, we know what it feels like. So I'm gonna ask each and every one of you to admit that if I prove to you beyond a reasonable doubt elements of the offense, that you all need to vote guilty.
I'm gonna object to any question that is predicated on the committees, obviously improper commitment.
No, this is not improper. The law, case law specifically allows for commitment questions so long as it is within the confines of voir dire and not giving any specific facts or elements to the.
I was just reiterating my objection, that's an improper commitment question.
Yeah, objection sustained.
Well, I'll rephrase that. What I'll ask is that if the evidence shows that the defendant is guilty beyond a reasonable doubt, can you vote guilty? Is there anyone that has an issue with that? If the evidence shows that the defendant is, that the evidence shows, if the evidence shows that the defendant is guilty beyond a reasonable doubt, you're convinced in your mind, is there anyone that has an issue with voting guilty? Raise your hand, look at me. Okay. Very good. Well, I thank everyone for your time, your commitment today. I'm looking forward to presenting a case in chief to you all. And I'm looking forward to meeting my burden and proving to you the charges beyond reasonable doubt. Thank you.
Mr. Kimler,
Yes, ma'am.
you may proceed.
Reiteration. According to the arm, is. I'd like to use the voting. I'll try not to use the whole 25 minutes, I'll just say that. With one of the times I'll up to whatever too. Really, it's one issue in this case that thinks come up should be self-defense. And I want to hit on that a little bit because the law is a little bit convoluted in that regard. Before I do that, it's important to realize anything that I say or anything the state says, the district attorney office says regarding the law or the application of the law, what the law is not binding on you. The law that's going to control your deliberations and control the trajectory of the course. The trajectory of the course of the trial comes from Judge Holmes on the bench. He's the one that is the master of the law that controls the law and will instruct you at the end of the case about all the law necessary for you to decide the case. That's the law that controls. They'll actually, I believe, tell you at the end of the case, the comments of the attorneys are not evidence and shouldn't be considered as such. Language that in that regard, advising you that what the lawyers say doesn't control. We're advocates on each side. But as far as what you're bound by, that comes from the court, not either the state or the defense in the case. So when I discuss the law of self-defense, understand that it's gonna be it's gonna be predicated on what I understand the judge is gonna instruct you in the court's instructions at the end of the case. I'm not attempting to tell you what it is. I'm relying on what I anticipate Judge Holmes is gonna tell you at the end of the trial. The law, obviously, everybody's familiar with the law of self-defense in general, right? Anybody that doesn't have an idea of what self-defense is, and you said you're an elementary school teacher, right? And it probably comes up on the playground, right? Now, in Texas, we have a little bit different way of doing things, of applying of self-defense, decided self-defense to cases that are involving assaults or murders or even things you think of when the state makes that allegation against someone. Well, but what the law is going to anticipate Judge Holmes is going to instruct you is that once the issue of self-defense is raised by the defense, once we introduce evidence to say that, hey, self-defense is around in this case, it may have occurred in this case, then Judge Holmes is going to instruct you that it becomes a burden of the state of Texas to disprove self-defense beyond a reasonable doubt. Okay, so let that sink in for a minute. It's not the burden of person accused of an assault or murder even to prove that they acted in self-defense. You don't have to believe that they acted in self-defense beyond reasonable doubt before you say not guilty. That come as a surprise to you, Sundgren, is that right? Does that surprise you that I anticipate that being the law that the judge is going to instruct you on?
No, that doesn't surprise me.
How do you disprove something beyond a reasonable doubt? How is that done? How do you disprove something? Not prove it, but disprove it.
You would find whatever, you gotta get the facts out of it, but if they're trying to, like something that you know didn't happen or couldn't happen, or, you know.
It's kind of hard not to think about that without maybe fleshing it out with an example. At least, how many people here are married, they have a significant other at least one point in their life, right? What if, and I'm not making this allegation, of course, Mr. King, but what if you suspected your significant other of cheating, right? How can you say, prove to me you're not cheating in this relationship? How would they go about doing it? Prove to you beyond a reason. Once you see evidence, perhaps, that it introduces the idea in your mind, hey, you're coming home late, repeatedly after work, you smell like alcohol, that maybe, you smell like unfamiliar cologne, perhaps, or some unusual, some charges on your joint accounts that are inexplicable. This maybe going by personal experience, really. What would you say to your significant other? Prove to me beyond a reasonable doubt that you're not cheating.
No, that's difficult. Because
Yeah.
all the things you mentioned are pointing in
Yeah,
that
in that
direction.
direction. But how would you to disprove that they're not cheating, right? That's the idea. How do they disprove that beyond a reasonable doubt?
That seems tough, yeah.
Right. It's a tough burden.
Yeah.
You understand? That's what the law, I anticipate the law is going to require the state of Texas to prove to you. To disprove self-defense if we get that instruction. Is that something that you think that you can consider? Maybe you can make sure you can give them a fair shake at that. I think so. Sure. What about you, Mr. Hollier? How would you handle maybe having to disprove, looking at something disproving beyond a reasonable doubt? Proving a negative, disproving a negative, right? Or disproving a negative. Proving a negative, right? How would somebody go about doing that? I would anticipate you're gonna see a video, right? That there's a recording. There's a recording perhaps that's gonna be introduced of the altercation, the question here. Maybe you can look at that. Make your own conclusion based upon the actions or ultimate actions of the actors. If they disprove it beyond a reasonable doubt. Do you think you could hold them to that burden? Right? Not require the defendant to prove that they were acting in self-defense. What about you, Miss Buer?
Yes, sir.
Is that correct? Is that correct?
Close enough.
What time is the correct?
Viewer.
Buer. What do you think?
I think that's a little different way to, look at it, but,
Why do you think in our state, why do you think it's looked at that way?
why do you think Texas?
Right, we're Texas, right? Why do we do it then?
I think that, people do have a right to defend themselves.
Mhm.
Um,
So whose burden should it be to prove? Should somebody be required to prove that, or should it be disproved if there's evidence that they did act?
right, and for them to follow, then you would have to prove that you did.
Right, and the state here has decided to put the burden on them themselves, the state, right?
Right.
To disprove. Other states are different. Well, I think you're from from Michigan,
Minnesota.
Minnesota. Yeah. You probably don't know what the law is up there, right?
I don't know.
Yeah, they do something different. Maybe you have to prove something in Minnesota. Yeah. But this is the way it's done. Texas has decided to do it. Ms. Cody, you agree with that? Do you think that's the proper approach, or maybe
I'm
we
trying to
should?
really understand, you're saying that you disprove?
Not me. Once the defense, it's our burden, the defense, to raise the issue, right? Maybe, like we're saying, it's coming home smelling like somebody else is cologne, like, just raise the issue, right? There's a suspicion, right? There's something, a little bit of it. We raise the issue. Then Judge Holmes, and again, I anticipate this, I'm not telling you that, I anticipate if we do that, Judge Holmes is gonna give you an instruction about self-defense, right? What self-defense is. And then he's gonna tell you, it's their burden. Their burden to disprove it beyond a reasonable doubt. In other words, they have to prove it didn't happen, and they have to prove it beyond a reasonable doubt. You think that is fair, or that makes sense?
Yes, I'm like, thinking like, if the facts are presented and, they narrow down so as much as possible, then we can't deny it. It has to be a lot of evidence that's pointing to that, had to have occurred.
Or pointing against it that it didn't happen, right?
Right.
Your district, right?
Right.
Yeah.
To disprove that, whatever you're saying, this has to be what had happened.
Right.
Nothing else could have.
But I'm just saying the fact that they have to disprove, right? You're on board with the state having to disprove self-defense and the defendant not having to
Yes,
prove it.
yeah,
All right.
disprove it.
What about you, Mr. Bowden? What do you think?
Bill, we get all the facts out, kind of hard to.
I'm just asking about the idea, this procedurally, are you okay? Does it make sense to you to think that the state has to disprove self versus us having to prove? Does that seem reasonable to you?
Absolutely.
All right. What about, Mr. Blunt, what do you have, what do you think? Yeah, I played on two of those Nederland teams where we lost for 19 years. My son played on three that beat y'all in a row.
Yeah. Now, we won state last couple years.
I know, I can't, Nederland's all of them. Digress here for a moment. But yeah, what do you think? Do you think it's fair that the state, or it makes sense, I guess I should say, that the state, that our legislature has decided that the state bears the burden of disproving self-defense once that's right?
It's the tough thing for the state, to,
What do you think it makes sense of them? It's something, if you're instructed, the judge gives you that instruction, you can follow without a problem, right? What do you think, Ms. Sandra? What do you think?
I would think that, yes, they would have to, you would have to prove that the facts weren't there. I mean, if it's a fact, and then you would have to, they'd have to prove that it wasn't.
Prove that self-defense did that beyond a reasonable, right? Okay. Sure. Mr. Callen, what do you think?
Well, the evidence is true facts, evidence guides you to the right conclusion, so anything doing that after review advance.
But there's a framework, a procedure of, rules that guide your considerations. And those rules say that the state has to disprove it beyond a reasonable doubt. Did you follow that, or would you have a, like in your mind, would you think, well, if somebody acted in self-defense, they need to prove that they acted in self-defense?
I could follow it.
You can follow the instruction, the court's instructions, they have to disprove. What do you think, Ms. Haley? I have to tell you, I mean, I listened to your answer to Mr. Vernon's questioning. And I can remember out on the playground at Langham Elementary, I don't know what school you teach at, the Wayne Band Needland, because when I was a kid. And, you know, there's pushing and shoving, and if you didn't push back, you just got pushed that much more, and it kind of made sense when you got pushed to push back twice as hard, you know what I mean, to stop it. So I don't know what y'all, are y'all teaching the kids just to take the pushes and not do anything?
We look at footage now.
Oh, you've got it recorded,
We got footage now.
okay, and so if a kid gets pushed first and they push back, the kid that pushes back gets in trouble?
Not necessarily, it's always case by case. We do, go to the footage, we hear both sides. Okay,
So you have experience reviewing videos and determining whether somebody's acting in self-defense.
but not just one person gets to determine.
It's like a jury, like how many people, is it 6? No, how many is it?
Hopefully 3.
3, and is the proof, is it beyond a reasonable doubt that they have to disprove they were acting, you have to disprove they were acting in self-defense? What's the burden of proof in your case for your children? When you're looking at 2 kids.
What am I trying?
Yeah, what burden, what standard are you holding your standard of review when you're looking at those kids, looking at the video footage of those kids on the playground? What school do you teach at, by the way? Okay. So you're familiar with food. So what are you looking at from this video? What do you look for?
Was the aggressor?
Who pushed first? What was maybe leading up to the push? So, all right, so one kid gets pushed and the other kid pushes back with equal force. What's the outcome there for you?
It's just a wash. Hate to say that, but,
So the one that pushes first gets off?
well, no, sometimes they both get the same.
But if the other kid's reacting to being pushed, why do they get treated the same as the person that pushed? Well, just be parents.
No.
I'm just thinking about my mother in that situation with me as a child. I probably would have had some problems.
Never gets too physical or somebody gets hurt. If somebody gets hurt, if the other person, no patient gets, the other person gets hurt.
Bloody nose, we're talking bloody nose.
They do react, are defending themselves. Most of the time, they do not get.
Okay. So if a kid gets punched and or gets a bloody nose and they fight back, and maybe, what if they bloody the other kid's nose?
No. Like I said, I don't know, I mean, elementary school. Me think it's something.
Well, I understand that, but I mean, I can understand too that I'll represent you when I was in elementary school, it was pretty much y'all settled it. Nothing ever happened. And so you had to learn to defend yourself. That's what the lesson that I took from the playground is, when you get pushed, you push back twice as hard and you get left alone. And that was a hard lesson for me to learn because I came from a family where there were no siblings, you didn't fight, and I wasn't used to, you had to learn quick that if you didn't defend yourself, you become a target, right? I mean, maybe things have changed with the video and supervision. But in any case, I'm just digressing here with this case. I mean, you would hold the state to the same, you would have difficulty holding the state to this group. Self-defense, right? That was my basic question. Miss Kepley, is that correct? What do you think? Miss Gavin? What do you you think it is somehow improper or unfair that the state has to disprove self-defense? Maybe it should be the burden of the defense to prove it? I think a lot of things, classes this morning. Yes, ma'am, I do. Thank you for the information. I'll take that under advisement. All right. Ms. Odell, I'll stop with you. What do you think is here for the state? I'd like to disprove truth beyond reason, or prove beyond reasonable doubt that his baby was not acting and so that charge is gonna shoot. You can follow that and what we're doing. All right, well, let's stand up.
10 more minutes.
All right, wait for 5 minutes. Proof beyond a reasonable doubt. All right, we talked about disproving something beyond a reasonable doubt, decided to proof beyond a reasonable doubt. How many of you think that this is such a great, important idea that Judge Holmes is going to give you a definition of it with jury? Do you expect it to be defined for you to tell you what it is? It's not going to be. All right, here's a case back in 2006 for the Court of Criminal Appeals. eliminated the definition of it, so there's no definition of proof beyond a reasonable doubt that binds you. He'll tell you that it's not proof beyond all possible doubt, so he'll tell you what it's not, but it's not, there's no positive definition of it. Mr. Vernon did a good job talking to you about the red light. I would suggest to you that probably embodies the previous, what we used to be given as the definition of proof beyond a reasonable doubt. But proof is such a convincing nature that you would be willing to rely and act upon it without hesitation, and most important of your own affairs, which kind of embodies the red light situation. That definition was given up until 2006. It was no longer given after that, so it opened it up. It's what basically whatever you think proof beyond a reasonable doubt is. I'm not gonna attempt to endeavor to give you a analogy or a metaphor of what proof beyond a reasonable doubt is. I would suppose, presume upon myself to tell you what it is. I'll simply tell you this, that to contextualize it, when you're trying to form an idea in your mind, what it is, you have to look at the consequences of a guilty verdict, which is what proof beyond a reasonable doubt is. It embodies a guilty verdict, right? Proof beyond a reasonable doubt, then it's a guilty verdict. Then you go on to punishment. This is a class A misdemeanor. Somebody could go to jail for up to a year. So the idea that the consequences of proof beyond a reasonable doubt, saying that that burden's been met, is punishment, and that's potentially depriving somebody of their freedom and their liberties and locking them up in the county jail out on Highway 69 for up to a year. That should I hope contextualizes how important it is. That burden be a high burden. Or somebody can be deprived of their liberty because that's the result of saying that burden has been met. And not to say that, that burden is met every day across this country, thousands of times and thousands of trials, thousands of people are in prison. We have the highest incarceration rate in the world in the United States, so obviously that burden was not a difficult burden for the authorities to meet. I will just essentially suggest to you, as Mr. Farner said, as representatives of the community, the whole of the state, that's not the state and the community, they represent the state, you represent the community. When you represent the community and you hold the state to their burden of proof, because the community, many of us sitting at that table under the same burden, but you just keep it contextualized that a guilty verdict means that somebody can be deprived of their freedom. Does anybody have difficulty or, I guess, disagree with that, or doesn't find that helpful? Anybody? Definitely, what do you think? You agree with that? Do you think it helps? Yeah. All right. Thank you.
Okay. Okay, ladies and gentlemen. Oh, okay, ladies and gentlemen. We're gonna ask that you go back out into the hallway. We may have to call some of you back in for some follow-up questions. So at this time, everyone please stand as the panel exit the courtroom. You could go out either one of the two doors.
I'll try to.
Okay. our court administrator, Ms. Brilla Balke, is going to call some names. If your name is called, we're gonna ask that you go up to the jury box. There are some tags that's on the top. You can take a tag, pin it to your clothing, and have a seat in any one of the chairs in the jury box. At this time, Ms. Brilla Balke.
Robert Bowden. Gussie Cody. Jeffrey King. Tyler Blunt. Mark Callender. Olive Gatling. Cynthia Odell.
Okay, ladies and gentlemen of the jury, I must administer to you the second of the two oaths that I mentioned earlier. I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, I do. Do each of you do solemnly swear or affirm that in the case of the state of Texas versus Keanu LaShawn Bailey, you would render a true verdict according to the law and the evidence, so help you God? Please say I do. Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The law comes from the statutes, codes, rules, and other court decisions interpreting them and how they apply to this case. You and I have equal authority, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses or objections to the introduction of documents or objects. This means that in objecting attorney's opinion, there's a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that we can discuss the matter more privately. The reason for this, as I told you earlier, you are the sole judges of the facts, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate. Therefore, you can't be present or within hearing when I discuss matters of the law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather his equipment and take it with him. And the attorneys would have to gather their files, etc. rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument until you retire to deliberate. Do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any sources outside of the courtroom anything about the facts of this case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper, on social media, or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The badges that you have, you'll be allowed to take those badges home with you. Please wear those badges when you come back to the courthouse because those badges identify you as a juror in this case. Ladies and gentlemen of the panel, those of you who were not selected, first of all, I would like to thank you for taking your time out to be here this afternoon. I know that some of you may be disappointed because you did not get a chance to sit on this jury. But you might think that you wasted your time, but you did not waste your time. And the reason why I say you did not waste your time is because, as I mentioned to you earlier, we have large dockets and we had several dockets. One of the dockets was a jury trial docket. We had a lot of cases on the jury trial docket. We were able to move some of those cases. And the reason why we were able to move those cases was people like you showed up to serve on the jury. So you did not waste your time because you helped us to move cases. Now, anytime that you're in the area of County Court at Law number 2, you can come and have a seat in this courtroom. I know that when you came here today, you said that, this County Court at, well, yesterday when you came, you said it's County Court at Law number 2. You looked over the top, you saw County Court at Law number 2, Judge Terrence L. Holmes, and you probably said to yourself, you know what, this is Judge Holmes' court, I'm in the right place. Well, this is not Judge Holmes' court. This is your court. This court is for the citizens of Jefferson County. I'm only a humble public servant serving the citizens of Jefferson County. I've said that to say this. Anytime that you're in the area of County Court at Law number 2 of Jefferson County, Texas, you can come and have a seat in your courtroom. In fact, you can sit in that area that you're sitting in. We call that the peanut gallery, but you can't bring peanuts in here and eat because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and see what goes on, and I'm sure you'll find it to be very interesting. Now, our bailiff have some letters for each and every one of you. She's going to give you a letter. And so if you feel free to drop us a line, feel free to do so. At this time, your jury service is concluded. Our county clerk, our district clerk's office is still open because they closed at 4:30. If you need an excuse from the district clerk's office, you can simply go right across the hall and they'll be able to give you the excuse that you need. Now, before you leave, normally I usually give everyone a handshake. However, COVID is still in our community, but I will give you what I call an air handshake. So on behalf of the staff here in County Court at Law number 2, thank you for coming out this afternoon, and each and every one of you have a blessed day. You are excused. Now, if you want to sit around and watch the trial, you can do so. And if you cannot be here in person, you can watch it on YouTube. All right. All right. State. Are you ready to proceed?
Yes, Your Honor. However, at this time, the state would move the court for a motion limiting.
Okay. So, okay, hold on a minute. They need to still be in here or? Hold on a minute. Hold on a minute. Hold on, let me turn all this off. Jefferson County Court, Alert number 2 is back in session. The court is in session in cause number 23 CCCR 0744, case is style State of Texas versus Kiana LaShawn Bailey. Let the record reflect that Ms. Bailey is present in court with an attorney. State is present with a criminal district attorneys. Let the record also reflect that the jury is now present and seated in the courtroom. State, are you ready?
Yes, sir.
Defense, are you ready?
Ready.
Okay. Ms. Bailey, would you please stand, and the state will read the information. And Ms. Nixon, are you going to read the information? You present the information?
Yes, Your Honor.
Oh, you may proceed.
And now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the county court at law of Jefferson County, Texas, that in Jefferson County, Texas, Kiana LaShawn Bailey, hereafter styled the defendant heretofore on or about April 16, 2023, did then and there intentionally, knowingly, or recklessly cause bodily injury to Madrika Marie Lee by striking her in the face with her hand, causing pain to the victim against the peace and dignity of the state.
And Ms. Bailey, how did you plead? Okay, you may be seated. State, would you like to make an opening statement? Okay, you may proceed. Oh. Before you do that, could you go? Hold on. He's gonna move that there. Oh, we went back up. Okay. Where? I guess it's down it's down the bottom. There it is, just, there you go, thanks. Thank you.
Good evening, ladies and gentlemen, jury, Your Honor, and defense counsel. My name is Farrah Nixon. I'm an ADA with Jefferson County, as we said earlier. Today, I want to introduce you to the state's burden and the map of our case. The first thing I want to go over to you is the elements of assault and bodily injury, which is what we're trying today. This is also what Mr. Vernon had gone over earlier, but I just wanted to put it up so we can see. This is the actual penal code of it. It's going to be, for assault, it's a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another. And that includes, we have to, what the state has to prove is that in Jefferson County, Texas, the defendant, Kiana Bailey, on or about a certain date, April 16, 2023, intentionally, knowingly, or recklessly caused bodily injury to another person who is Madrika Lee. Look at these. Intentionally is a person acts with intent when it is her conscious objective to engage in the conduct or cause the result. Knowingly, a person acts knowingly when he is aware of his conduct is reasonably certain to cause the result. And recklessly, a person acts recklessly, but she is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist for the result should occur. Bodily injury is physical pain illness, or any impairment of physical condition. So bodily injury could be represented just by someone striking someone and then causing pain. It doesn't have to be a broken limb, it doesn't have to be, they sprained their ankle or something, but what it has to be is it has to cause pain. I just want to leave those up for you to look at, just because this is what the burden of proof is for us beyond reasonable doubt. So the state has to prove these elements beyond a reasonable doubt, and if it is proved beyond a reasonable doubt, then the case is met, and we would ask you to return a guilty verdict. However, I need to introduce the elements of the case. I've already introduced elements, but I also want to introduce the players of the case, the defendant, the witnesses, and the relationship, the family relationship dynamic of it, just so you can understand. Okay, so we'll say that this is Madrika Lee, who is the complaining witness. This is her father. This is her mother. Okay. Then this is her father's first wife, second wife, third wife. So this third wife has a child and a grandchild. This grandchild is the defendant. This is the complaining witness's sister, Anita. So the reason why you need to know this is because there's a family matter that's discussed, and it's the basis of the issue at hand that was between the defendant and the complaining witness's sister. Not with the complaining witness, not with her mother, not with her father, but the defendant, the grandchild of the third wife of her dad, and her sister. So there was no beef between these two. No, there was no issue between the complaining witness and the defendant. Now that I've introduced you to the characters in play, I would like to tell you that the facts of the evidence will show that the state's going to provide is that on April 16th, 2023, the defendant, Keon Bailey, went to the HEB grocery store at 3025 Dallin Road in Beaumont, Texas, Jefferson County, and assaulted Madrika Lee. Madrika was there working. She worked for one of those, shopper apps where they go buy your groceries for you, they bring them home to you, that kind of thing. So she was working with one of these apps, shopping in the grocery store, when someone came up to her and introduced herself, which was the defendant, Keon Bailey. Because the complaining witness, with the relationship so distant, she didn't recognize Keon Bailey. And she says she remembers her as a juvenile. She hadn't seen her really as an adult and didn't really recognize her. So Keon Bailey introduced herself to the complaining witness, says, "Hey, I'm so-and-so's, the third wife's granddaughter." So she said that Kiana is the stepniece of the complaining witness. That's my rude back there because it gets little. And what it is she introduced herself and she said, "Hey, we had an issue between my family and a member of Anita's family, and she was trying to get a hold of Anita." And Mrs. Lee, Miss Lee was saying, "I don't want to be a part of it. I'm not a part of it. I don't want to get involved. Y'all need to hash it out yourselves. You need to discuss it yourselves." And they talked about that for a while in the grocery store, and then they split ways. Miss Lee went on and she went to do the rest of the grocery shopping, and Miss Bailey went about her business. A few moments later, Miss Bailey sought out Miss Lee again, and about the same subject, the same matter, and she wanted to discuss it again, but Miss Lee was on the phone, and she came up and wanted to discuss the matter again. And Miss Lee said that, she wasn't a part of it, she wanted to be a part of it. And then some words were said, they go back and forth, and then you'll see Well, that we can discuss in a minute. But then Miss Bailey reaches out and pushes Miss Lee so hard in her face that she falls against the shelves in the back on the grocery store aisle. And then you'll see that Mrs. Lee tries to defend herself from the attack, and they go back and forth fighting. And that at one point, on the ground and scared for her life, Mrs. Lee will grab anything, try to grab anything off the shelf. She grabs something. And then they continue the fight, and Miss Bailey continues to attack Miss Lee until another shopper comes and separates them. So it wasn't like, okay, we finished, we're done. We did all this. Miss Bailey continued to attack Miss Lee until someone else came and stepped in. So after that, Miss Lee contacted the police. She filed a police report, and she went to the emergency room approximately an hour later for complaining about pain on her forehead and across her face. Okay, so the evidence that we're gonna bring to show, to prove the things that I've discussed here are gonna be pictures of Mrs. Lee's injuries that include a hematoma on her forehead, a cut on her by her eye, busted lip, and a scrape to her hand. You'll also hear Mrs. Lee's testimony about how she feared for her life during the assault. And that the state will also show you a recording of the HEB security video so that you can actually see the assault as it occurred. And the testimony will also provide testimony and body worn camera of the officer that investigated the assault. And once the state is confident that once we've showed you all this evidence and you apply that evidence to the laws and the elements that we have to prove, that you will find that Kiana Bailey is guilty of assault and bodily injury, and that we're going to ask you to return that verdict of guilty for assault and bodily injury. Thank you.
Okay. Now, and Mr. Kimber, you waiving opening? You're gonna reserve it?
Reserve it. Yes.
Okay, okay. State, you can call your first witness.
Your Honor, at this time, the state calls Officer Deanna Wilkes.
Wilkes, Officer Wilkes. Okay. Officer Wilkes, would you please come forward? Please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may put your hand, you can take the witness stand, you can adjust the mic in the chair. Attorney Vernon, you may proceed.
Thank you, Your Honor. Officer Wilkes, how are you today?
Fine, how are you?
More than thank you for asking. Will you please introduce yourself for the record, stating your first and last name?
Officer Deanna Wilkes.
And would you also state your occupation for the record?
I'm a police officer with Beaumont Police Department.
Are you a duly sworn and certified peace officer in the state of Texas?
Yes, I am.
And with who currently holds your license, your badge as a peace officer?
Beaumont Police Department.
And how long have you worked for the Beaumont Police Department?
I've been a police officer with Beaumont Police Department for 10.5 years now.
10.5 years. And over those 10.5 years, had your role or title, has it changed over time?
Yes, I was a patrol officer for 9 years. For the last year and a half, I've been a public information officer, and I work PCR, which is Police Community Relations Division.
Can you describe for the ladies and gentlemen of the jury, your educational background?
I do have some college education as far as a criminal justice degree that I'm actually pursuing now with Lamar University. But I also completed the academy with LIT in December of 2015.
I am a certified hostage negotiator with the state of Texas, and I was a field trainer for 5 years.
What's your training for, hostage, negotiations? What's that like? What did you learn from that?
It's actually it's a pretty substantial course that we take. It really teaches you how to talk to people. Not so much in an investigative state like we normally do, but more so building rapport, and really trying to understand where someone's coming from.
How long did it take you to complete that course?
The course itself is about 40 hours of coursework. Being on the actual hostage negotiators team, we meet and do training each month outside of any type of call outs or anything like that.
On April 16th of 2023, were you employed with the same agency that you're employed with now?
Yes, sir.
And back, on 4/16/2023, what were your roles and responsibilities? Were you in law, patrol division at that time?
Yes, at that time I was a patrol officer, and my primary responsibility was answering calls for service.
Answering calls for service. Did that include answering calls for service, with regard to assaults?
Yes.
When you were responding to a scene, and you got a call for an assault, is it important to know, once you arrive on the scene, is it important to know who the victim is, who the aggressor is, any other threats? Or, is that an important thing that you want to determine when you arrive on the scene?
Yes, tactically, you want to look for your threats first, to make sure that your scene's as safe as it possibly can be. And then you want to start your investigation, figure out who's who and what's what.
In particularly on 4/16/2023, do you recall responding to a dispatch call for service at around 7 p.m.?
I'm referring to my report.
Mhm.
Yes, at about 7:36.
And you were in uniform when you responded to this call?
Yes,
Were you in a clearly marked Beaumont PD vehicle at that time?
yes.
And when you responded to the call, where did you go? Where was the event? Where did the assault occur?
Honestly, in the center of the grocery store. I entered through the exiting doors. And I don't remember his name. I was met by one of the managers, Mr. Thibodeau. I was met by him, and he started kind of giving me a breakdown of what was going on as we continued walking through the points of sale, the actual registers. And as we continued forward, he started pointing out who was who and what actually happened.
Which grocery store? Would you tell the ladies and gentlemen of the jury, which grocery store was that?
It was the HEB pantry located on Dowden Road.
HEB on Dowden Road.
Mhm.
And were you wearing a body camera that day?
I was.
Are you a competent operator for that body camera?
Yes.
Did you activate that body camera?
Yes.
Right. And so when you arrived on the scene, you said you were greeted by a manager, Mr. Thibodeau, is that correct?
Yes.
Okay, and after he walked up to you, you greeted you at the scene, what did you do next? What happened next?
I started making contact with the subjects that he started pointing out of what exactly was going on. The first lady I spoke with was Miss Lee. And I had a conversation with her while another officer that was coming to assist me, he ended up speaking with the other party that was on scene, Miss Bailey.
And just for purposes of explaining and confirming for the court and ladies and the record, HEB is located in Jefferson County, is that correct?
Yes.
Okay. And you said that you had spoke to Ms. Lee, and you said you had spoke with the defendant, is that correct?
Well, I did speak with her later, but initially, while I was speaking to Miss Lee, my secondary officer that showed up with me was speaking to Miss Bailey.
Now, when you saw Miss Bailey, do you recall what she looked like?
Yes, I do.
Okay. If Miss Bailey's present in the courtroom, could you please point her out and identify an article of clothing?
She's in a white dress.
Your Honor, please let the record reflect that the witness has identified the defendant.
The record will reflect that the witness has identified the defendant. You may proceed.
Okay, so once you arrive on that scene and, you're with, Mr. Thibodeau, he's pointing out who's the victim, he's pointing out who's the defendant is, and, you said one of your other, your co-officers securing the scene. And then what did you do after that? After y'all passed through and made those points, what did you do next?
I spoke with Miss Lee first, just to get her account of what happened. She let me know that she.
Objection, hearsay, non-responsive.
Objection sustained.
So you spoke with, Miss Lee when you arrived, is that right?
Yes,
Okay. When you first made contact with Miss Lee, what was her demeanor like?
she was visibly upset. I could see that she had, a mark on her forehead. She started explaining what was going on, and we ended up having a conversation from there.
What was that mark on her forehead? What did that look like?
It was a laceration, kind of, I actually notated what it looks like. Was a scratch that was right between her eyebrows.
And did you come to learn, why her demeanor was upset? Did you come to learn how she had, gotten that laceration and scratch from?
Objection, also hearsay. It's predicated on a hearsay statement.
Your Honor, she's allowed to say what's within the scope of her personal knowledge and what she came to learn as a result of her having her discussion with Miss Lee.
She can testify what her understanding was,
That's all I'm asking.
but that's a different question.
Yes, objection sustained.
Can you please tell the ladies and gentlemen of the jury what you came to understand about with regard to how she sustained it?
From my understanding, she was assaulted,
Assaulted by who?
Miss Bailey.
And as a result of your investigation, did you come to learn how the assault or how the events that unfolded that resulted in you being dispatched to the location? Did you come to learn how that assault unfolded or occurred?
Yes,
Objection, Your Honor. I think again, that would constitute testimony predicated on hearsay. How did you come to learn how the assault occurred? That's assuming that facts
I'll
were
refer-
related or alleged facts were related to her that form this to protest.
Okay, objection sustained.
What did you come to learn about the assault, how it occurred? What did you come to learn?
Again, I would project as far as what it's phrased, how you came, what she learned about it. Did she form an opinion? Did it result in an arrest or something of that nature? What was her actions based upon what her understanding was, not what you came to
So
learn?
what is your objection?
That is, again, it's predicated on eliciting hearsay. This hearsay within the question that's embedded in it.
Okay,
She has to predicate her answer on hearsay.
Okay,
it's
objection
hearsay with
sustained.
Your Honor, she's speaking about what she learned in her mind. It's no difference between someone.
oh, you're saying that you saying what she learned from an investigation?
What, that was the question, what she learned from her investigation, correct?
I would not object if the question is, what did you do as a result of your investigation? What did you do? What actions did you take?
Right.
I wouldn't object to that, just to be clear, but if he's saying what you learned, then that's asking for hearsay, as if he's asserting that.
If it's based on somebody else's statement,
Statement, right.
right?
Correct, but correct, if it was based solely on someone else's statement, Your Honor, but the officer learned things about this and how it evolved based on other information, not simply a statement. There was video footage, there was things that she learned.
And just to be clear, what actions did you take as a result of your investigation? Obviously, it's not objectionable.
Right.
It's-
Objection sustained. Okay, you may proceed.
So, what actions did you take as a result of conducting your investigation and being dispatched to the scene?
I asked the store manager if he could find video footage of the actual altercation. He was able to find it, and we were able to go back on that footage to kind of see how both parties had moved through the store.
And as you mentioned, you saw how the party moved through the store. How did they move through the store?
From what I saw on the actual video footage,
not anything that evidence, hearing your honor.
Objection sustained.
So, we're gonna move here, and we're gonna talk about we're gonna lay the foundation for it, okay, for the ladies and gentlemen, we're gonna lay the foundation. Was your body camera active at the time you, viewed, the footage and at the time you arrived at the scene?
yes,
Was that device capable of making accurate reports?
yes,
Are you a competent operator of that device?
yes,
Permission to approach, Your Honor?
Yes.
Officer Wilson, I'm showing you what's been marked as, states exhibit, 1, 2, and 3, which contain your body cam footage that you wore that day, that you responded. Did you have an opportunity to review this footage?
yes,
Is it a fair and accurate copy of the events that occurred that day?
yes,
Has this recording been altered in any way?
no,
And I have a few follow-up questions. HEB was pretty busy when you walked in there, is that right?
yes,
And, is it normal for body cameras to pick up ancillary sounds from people around when you're walking in HEB and there's?
yes,
Is it possible for you to identify every single voice that came in on that background information?
no,
And, whose voices do you know for sure that appear on your body camera footage as you reviewed on the other day?
mine, Miss Lee, Miss Bailey. I spoke directly to, Mr. Thibodeau. And you can hear me speaking with, the other officer on team as well.
Very good. At this time, Your Honor, state with, send the video, body cam footage to the defense and ask them to.
I can clear up.
Okay, you want to take the witness on board?
Yes.
Okay.
We've got 3 different flash drives. Is your body camera 3 different ones or is it?
I don't believe so.
So what are the other 2? Is it,
I believe mine is on the black.
well, there's 2. And one, but what are? This is your body cam?
I do believe so.
Wilkes? Response to case?
Yes,
Have you reviewed this before testifying to this?
yes,
Okay. So what are these other 2?
I'm not sure.
So you didn't review these?
No,
Okay, so just this one.
yes,
I'm not trying to, I know. So you sure you'd look at I guess there's a blue one that says HEB surveillance, you didn't review those?
no,
Let me ask you this, sometimes police, they'll copy the surveillance camera onto their body cam and then use that as a surveillance, is that what you did here, or just, yeah,
I don't know.
you don't tell, okay. All right, as far as the one that's Wilkes, right,
Yes,
the one that you reviewed, is this from the entirety of your interaction there? There's no portions that have been added or deleted, just
No.
the entire body cam?
yes,
And initiated when you exited your vehicle?
actually before I entered my vehicle.
Are there any returns or anything on the radio traffic appearing on here? Do you know?
I don't recall.
Do you recall running criminal histories on anyone on this body cam? Or no?
I don't recall that either.
Okay, so there could be criminal histories on here? Or do you
I don't believe so. There shouldn't be.
There's voices of Ms. Lee, you stated, the HEB manager, and who else, your partner?
Majority of the people that I actually spoke directly to, so yes,
When you spoke to Ms. Bailey, the defendant, was that a custodial interrogation? Was she under arrest?
no, she was not under arrest, but she had been detained.
Was she Mirandized prior to getting?
No, she was not.
Was she in custody?
No, she was not.
She free to leave?
No, she was not.
Well, but she wasn't Mirandized, is that correct?
Correct.
Your Honor, I would object at this time. I don't have any objection to the visual portions of this, but as far as the audio portions, this, I'll start with the defendant. I would argue that this was a situation where she was not free to leave. It's not necessarily an arrest, but certainly a custodial situation, that any statements were provided to law enforcement without her being properly Mirandized, and under Article 38.22, it's not a proper statement, or not an admissible statement of the defendant. It's not a statement against interest. It could be construed as a confessionary type of statement. And then as far as the other statements on here, I reject that they're hearsay and violate right to confront and cross-examine. But again, I don't have any objection to the visuals.
Okay, Shay,
And again, these other ones, I would object if these haven't been properly authenticated yet, the surveillance. I don't, are they all one exhibit, or are they all?
Yeah, it's all.
I would object to the, I guess, the subparts of the state's one. Thank you.
so, these objections will be sustained at this time?
And again, I don't object to playing.
I understand.
So, Your Honor, I'm gonna ask some questions to see if we can, relay the foundation, clarify the issue.
Okay.
Officer Willis, when you uploaded your body cam footage, did you break that down into 3 different videos labeled HEB in all 3 of those videos?
Yes.
And so, as you broke those down, those 3 videos, while you reviewed all of them, correct? You simply didn't see them on single flash drive. You saw a single flash drive, but you did review all 3 clips on yesterday.
Yes, I did.
And those are accurate depictions of your body cam footage.
Yes.
Okay. And I'm gonna go to the scene. When you arrived on the scene, was it still a status of excitement, and or how was the scene? How did the scene appear when you got there?
It was a little stretched out. I mean, from my understanding, they had just broke up the fight and got them separated. So there was still some excitement going on.
Okay. So is it when you were there, you were asking questions, you were still gathering evidence, is that correct?
Yes.
Were you still responding to an emergency at the time?
Yes.
So you were still responding to an emergency at that time?
Yes.
Your Honor, at this time, the state would move to readmit these devices, as the witnesses stated that she did have time to review, and it is her body cam footage, and she did submit 3 separate franchises of those records, and they simply are manifested in.
I guess I'm not clear, again, whether she actually reviewed, Your Honor, these flash drives that they're offering.
Okay, you wanna
Yeah.
take on Vardar
Well,
to clear it up?
did she actually, briefly, I mean, did you actually review these flash drives?
So again, I reviewed all footage yesterday, both body camera and the other 2 clips that were created. If they are on separate flash drives, I don't recall that.
Oh, sorry, I understand. We're offering things into evidence, right?
Understand.
These are what's been offered into evidence, so you have to review these.
I understand that.
So did you look at these?
Again, if that is the other 2 clips of the footage from the store, then yes, I did.
Did
But
you-
if they're on those flash
I'm not
drives,
talking
I
about,
don't know.
I'm talking about these, this right here. Did you put this in and look at this?
I did not.
Okay, or this?
I
This
did not.
thing right here, put it in and look at this, what's on here?
I did not.
Okay, that's my question, then. She's got, we don't know what's on these
Well,
particular drives.
Okay, Mr.
Because these are what's going in the evidence.
Burner?
Your Honor, the defense did stipulate that they don't mind the body cam being played, so long as it excludes audio.
I wouldn't mind these being played if we knew what were on them. If somebody had reviewed them and looked at them, if it's not objectionable, if they can be authenticated. But that's the problem. I don't know what's on these flash drives. And she doesn't either because she hasn't looked at them. So we don't know what's on these. That's the issue that I've got.
Okay, let's do this. We're gonna take a few minutes break and ask the jury to step outside for a few minutes.
Yeah, I'll see.
Officer Wilkes, who was depicted there in the camera? Do you know,
Yes, that's Miss Lee.
the victim in this case?
Yes.
Okay. Do you know who that is walking up there behind her?
Yes, that's Miss Bailey.
Um. So, can you walk us through what you just saw?
From my understanding, Miss Lee was walking toward the front of the store. Miss Bailey caught up to her, a second time. And they began to have a verbal altercation. During that altercation, when you see Miss Lee's hand go up, that is a cell phone in her hand. She has someone on speakerphone. They continued to have a verbal altercation in which whatever words were exchanged. Miss Bailey steps towards her in an aggressive manner and pushes her in the face.
So she pushed her in the face.
Yes,
She stepped towards her in an aggressive manner.
yes.
Now, did the victim hit Miss Bailey first? Or did Miss Bailey come and launch at, Miss Lee first?
Miss Bailey hit Miss Lee in the face first.
Now, at this point, has Miss Lee done anything to punch back or hit back? Is anything at this point, has she done anything?
No.
We can't really see where her hand is, but according to what you see, where's her hand where's the defendant's hand located on Mrs. Lee?
From what I can tell, it looks like she's actually holding her hand. And what I would determine in an attempt to stop her from putting her hand.
So you would say that the victim is in a defensive position, holding her hand
Objection, the officer, speculation, Your Honor.
What
Also,
was it?
the video,
Oh, yeah.
the video speaks for itself of the officer, or the officer's commentary and introduce the evidence. But I would say it speaks for itself. I object to the relevance of the officer's characterization of the actions and the rest of the jury's determination.
Your Honor, the officer has, made it clear that in her training, she, evaluates these types of situations and to make a determination who's the aggressor and who's not. She's already testified.
I don't know if the state's proffering this officer as an expert witness to render an opinion about what is going on, is being aggressive or not. But again, that element up to the jury. The officer's not particularly qualified. Objects to the relevance of the testimony. Any probative value that it has under Rule 403 is outweighed by the unfairly prejudicial nature of the characterization by the state of these actions, or by the witness of these actions.
Okay, objection sustained. Okay.
Officer Wilts, what did you just see there? What actions did the Miss Lee take?
Your Honor, I'm gonna object. The video speaks for itself as far as what could be seen or not. What the officer sees, the officer's opinion, interpretation isn't relevant. She's not being proffered as an expert witness in any, or hasn't been qualified as an expert witness in any type of area that would render this, her opinion to be helpful to the jury to make their final determination. Objection, she hasn't been qualified as an expert in the opinions. Doesn't contain probative evidence and is irrelevant.
Your Honor, the officer is simply testifying to her observations that were recorded on her body camera. And while she's not an expert witness, she is allowed to testify on what she saw.
She's rendering an opinion, Your Honor.
There are no legal conclusions made in what she's observing.
Objection sustained.
Officer Wilson, you had mentioned earlier, that, when this altercation and assault had occurred, that this wasn't their first interaction. Was that your statement earlier?
Correct.
So were there prior interactions or what happened?
Yes, in another clip where they originally meet, Miss Lee is actually shopping an Instacart order for someone else. She approaches the season aisle. She selects something off of the aisle. And there is someone standing there. Well, when you look at the footage, it's Miss Bailey. Miss Lee doesn't appear to say anything or even look at her. When Miss Bailey moves out of her way, Miss Lee grabs something, she puts it in her basket, she turns and walks away. As she gets a few feet away from Miss Bailey, she turns around and they have a brief conversation in the aisle.
And then they proceed here?
There is a time difference. So at 7:18, they appear to have that conversation on the aisle near the spices. Miss Lee continues, they talked for about 5 to 6 minutes. Miss Lee walks away from Bailey after that conversation, and Miss Bailey appears to walk in the opposite direction. And then at 7:33 hours, so roughly about 15 minutes later, Miss Lee is, this is the clip of the next part where Miss Lee is walking down this aisle, which I notated was aisle 38. And while she's about to make another selection, Miss Bailey approaches her again.
Okay, so and just so that you're understanding, and tell me if I'm wrong, but you're saying that Miss Lee shopping on one aisle, they have a discussion, and then she walks away from that discussion. Miss Lee walks away from that discussion and enters this aisle here. Is that correct?
About 15 minutes later.
About 15 minutes later, she walks this aisle here.
Mhm.
Only then does the defendant walk behind Miss Bailey and come after her again. Is that correct?
Yes.
Okay. So Miss Lee leaves after their altercation, their first interaction, and then Miss Bailey follows her to this section here.
Yes.
And then that's where she continues, that's where she goes and
Yes.
pushes, Miss Lee in the face. Is that correct?
Yes.
And you testified earlier that there were some lacerations. Did you come to learn that was how she sustained those lacerations from this interaction here?
Yes, once I saw the video footage, it was, clear that some of the injury that she had was from the altercation. She also had some type of laceration on the back of her left arm.
Did you take any photographs of the injuries?
No, but her injuries were notated on my body camera.
And based on your training, experience, what's mutual combat? Have you heard that term?
Generally, a mutual combat fight is where you all have made a consensus, and it is a consensus to fight each other, in the sense of there's an agreement that we are going to have a physical altercation with each other.
And at any point in your investigation, did you find whether there was a consensus to or agreement to for these two to fight?
No.
So there was mutual combat or no in this situation?
From my investigation, no.
There was no mutual combat?
No.
Okay. You know, based on your training and experience and in your investigation, who did you determine on the scene, who did you determine was the aggressor in this situation?
Miss Bailey.
What led you to that conclusion?
After completing the investigation of actually speaking with both parties, hearing what each side had to say and what they determined had occurred. And then upon watching the video footage, it was a little clearer that Ms. Lee had given me a play-by-play from the very first interaction all the way up to what led into this situation here, that we just watched the actual physical altercation, and that Miss Bailey was the one to make physical contact first.
And your investigation yielded results that, Mrs. Lee's testimony to yourself and your investigation matched with what was recorded that.
Yes.
No further questions.
Okay.
Let's take it past the rules.
You know, if, actually, I'm sorry.
Yes, you may proceed.
We discussed the first, interaction between the two.
Yes.
correct? Is that what's depicted on stage 3, the other flashback that's we seen this one?
Can I see what that's marked as?
Initial comment.
Yes,
So this would depict what you testified to.
yes.
States, I guess this is 2, right? We need actually stick it in, but I'll let the state do that. This is states 2. So this would be what you described, we depicted on, this would depict what you described as the initial
Yes.
contact between the two.
Yes.
That hasn't been published.
You have stickers on them?
I don't want to publish it.
Okay.
I just wanted to clear it up, but it is depictable.
Yes.
Yeah, as part of your investigation, did you determine that during the course of this altercation that Ms. Lee deployed an object?
Yes.
And what was the object she deployed?
I believe you're referring to a candle.
What type of candle?
That part I don't know.
Well, was it simply a wax candle, or was it one of the candles that's encased in a glass?
I believe it was a wax candle.
Encased in the glass type? candle?
Yes, a glass, yeah.
Now, did you attempt to retrieve that item or not?
No, from what I remember, once we pretty much got there, they had already started cleaning most of that stuff.
Was there broken glass?
I do believe there were some pieces that were still there.
So part of the lacerations, I guess, on Ms. Lee's arm could have be attributable to the glass?
It could have, but she did not tell me that that was what it cost her.
Did you observe broken glass, or did the staff at the store show you the glass? Or,
Yes, the Mr. Thibodeau had pointed it out to me.
and again, it would have been one of the candles, the large, I don't say large, but a candle about this tall.
Again,
glass.
I didn't actually get to see it because they had already started cleaning it up. There were some pieces of glass still on the ground, but Mr. Thibodeau did let me know that was a broken glass.
Was it your understanding that Ms. Lee had struck Ms. Bailey with that candle? That
Yes.
glass candle?
I was advised of that.
In your training, I guess, not necessarily experience, but your training, that's the use of a deadly weapon, isn't it? It's use of a weapon,
It is the use of a weapon.
and a deadly weapon is what? Weapon capable of
It's
causing
capable,
death or
yes.
serious bodily injury,
Here's about injury, okay.
which can be almost anything, right?
Yes,
So if a person employs deadly force using a deadly weapon in the context of a fight, would that alter, when the other person doesn't, right?
Mhm.
That doesn't alter your calculation about how to approach the incident?
not in this situation, because you can actually see it on the video footage when it occurs.
But we have a case where one person is deploying deadly force against another person who's not deploying deadly force.
Yes,
We can agree with that?
yes.
Objection, Your Honor. She's already stated that a candle is not deadly force. She stated it is a weapon, but it's not deadly force. So I would object to a characterization of the candle as deadly force.
If it's a deadly weapon, right, it's capable of causing death or serious bodily injury, and somebody uses it, then that's deadly force in the context of self-defense.
But did she say that was a deadly weapon?
I believe she did. It's capable of causing
Not
death.
in this situation, not in the manner that the candle was used.
No.
Okay, objection sustained.
Let me ask you this, is the candle itself is capable of causing death or serious bodily injury, right? A glass candle,
Objection, Your Honor. That's outside the scope. She's not a doctor or biologist. She doesn't know what particular weapons might cause. I mean, it's just way out of the scope of her personal knowledge.
It's
She's
a
not an
legal-
expert as the.
it's a legal question. The deadly weapon is defined legally as anything that's capable of causing death or serious bodily injury.
Yeah.
What-
She's not an attorney, Your Honor, so she's not, those are findings of fact for the court and that's gonna be finding laws for the court, finding facts is for the jury, not for the witness.
She's given an opinion as far as who was the aggressor, Your Honor, and as far as how she filed the
Yeah, but
case.
she stated
So-
that wasn't a deadly weapon, so his objection is sustained.
Well, is it your opinion that that candle is not a deadly weapon? It wasn't, the glass candle is not capable of causing death or serious bodily injury?
Your Honor, you've already sustained the objection. She can't test, she's not an expert on what's we call verbal, what, you know.
The problem here, Your Honor, she's testified of her determination of what she, the decision she made of how to file this case and who was the aggressor. So she's given a legal opinion as to how the case was filed. So I think they've opened the door a little bit to this inquiry as far as the legal rationale of how the case was filed and why it was filed in a particular way. So my question is, if one party deployed a weapon, and I would argue a deadly, capable of causing death or serious bodily injury, that's a broad idea. There's been shoot, all types of things that are held to be deadly weapon. That wasn't part of the consideration that she gave and what she decided to do and how to file the case, which may have opened the door to. Since one party did use an object that's arguably a deadly weapon and the other one didn't, she did something she didn't consider when she filed the case at all.
Okay, Mr. Vernon?
Your Honor, a person's hand trained properly can also be a deadly weapon, and that's again, a legal conclusion, because it is so broad. A hand could be a deadly weapon if used properly, just like a candle, or just like a pin. So again, the classification of a candle as a deadly weapon for purposes of this trial is prejudicial and it's irrelevant.
Okay, objection sustained.
All right, I'll move on, but we can agree that one person used an object, a weapon, or something that was used, employed
One person did use an object.
to strike Ms. Bailey, right? Or
Yes.
you said, and Ms. Bailey didn't use an object, or weapon, right?
No.
That's what.
Okay. Mr. Vernon?
Officer Willis, we reviewed the footage together, right?
Yes.
And we saw that the defendant struck with her hand open, closed, whatnot, struck the Mrs. Lee, correct?
Yes.
And the candle was deployed thereafter, is that correct?
Yeah, it was further into the physical altercation.
We'll watch it again, so we don't see when the candle. But we just watched, so. The defendant struck Mrs. Lee, correct? That's what we just witnessed?
Yes.
Has Mrs. Lee grabbed an object or anything at this point? At this point, after she
No,
struck?
she's only grabbing Miss Bailey.
Okay. So no candle?
No.
Officer Wilson, has there been a candle used at this point in the fight, which you can see?
No.
So it's honest and truthful to say that the candle was used against, Miss Bailey only after only after being Miss Lee was struck in the face. Is that
Yes.
no further question?
Nothing further this witness, John.
Mhm.
Nothing further this witness.
Okay, may this witness be excused?
Yes, Your Honor.
I don't anticipate recalling her, but I know she's gonna be available tomorrow. I would like her subject to recall. I don't anticipate it. I hesitate just to waste time, perhaps even recall it or clarify it as they.
Okay. Okay, Officer Wilkes, you're free to go well, you need to be on standby. So if the state or the defense, need to, recall you, you have to be available.
I don't anticipate recalling her, but I hesitate to just let her. fly
Okay.
through, fly away, because there may be an evidentiary issue that comes up regarding the surveillance video or something else.
Okay, okay.
Can I talk to you about that?
Uh,
Commissioner Coach, Your Honor.
yes. Okay, so, Mr. Kimler?
I don't object to being.
Okay, so Ms. Officer Wilkes, you're free to go. And you have a blessed day.
Thank you.
And we, pray everything is fine with your grandma.
Thank you so
You have a
much.
blessed day. State? That's the only witness you have for today.
Yes, Your Honor.
Okay, so, ladies and gentlemen of the jury, this will conclude the testimony for today. And so on tomorrow, we will resume with testimony at 1:30. And we'd ask that each and every one of you be on time so that we can start at 1:30. You'll have a seat out in the hallway. And then when the bailiff is ready to come get you, then we'll resume with the trial. So at this time, everyone please stand as the jury exits the courtroom. Okay. Well, we'll be recess,
What time? 1:30?
1:30.
I'll be back.